Okay, I think we got it going. I'm going to move that out of the way. Hello, this is Keith Davidson,
And this is Stewart Albertson.
and we're from Albertson and Davidson, and this is our first live stream on YouTube. So we're trying something new. We do a lot of videos. We try to do a lot of educational outreach to the public to try and teach you as much as we can on trust and will issues. And we thought it'd be kind of nice to have some sort of forum where people can come and actually ask us questions, a live Q&A. And so our plan is to do this once weekly, every Friday. And hopefully, if you have trust and will questions, we have trust and will answers, and we can try and answer your questions as best we can. So that's kind of the purpose of why we're here today. And while we get started and while we wait for some people to come into the live stream, we have a few issues that we'd like to talk about, and we can start there, and then we can kind of see where it goes.
Yeah, so obviously we do trust and estate litigation. That's the primary thing that we do in this firm. We are a litigation firm, so if you have any trust and estate questions that have to do with litigation, please join the live stream and let us know your questions, and we'll do the best we can to respond to those. One of the things that I wanted to talk about briefly with Keith is a new case that came out a while back dealing with expert witnesses in California. And this is an issue that we see quite a bit in our cases where we need to hire an expert psychiatrist, a forensic psychiatrist, to go back and look at the medical records and make a determination to see if a decedent was suffering with Alzheimer's or dementia. And if so, were they susceptible to the exercise of undue influence because of that weakened state of mind? And what some lawyers were doing is they were hiring experts to come into court and just make speculative statements. For example, in the trust and estate world, an expert would come in and say, well, with dementia, if you're taking the right medication, it'll actually stop the progression of the disease and it may even reverse the disease. Well, that's just mere speculation because there's no studies that show that that happens. And so then what experts would do is they would go out and try to find some evidence to support a speculative statement. And so now they're saying my statement's not speculative because I have found research and data out there. It may be the only piece of research and data out there that shows that dementia can be reversed, the disease can be reversed, the cognitive deficits can be reversed. And everyone in the mainstream would tell you that is not the case. And so what the court came down and said is not only do we not want experts to give speculative opinions, we don't want them to base those opinions on speculative data. And so when we're hiring experts, in fact, when we cross-examine experts that are hired by the other side, what we want to do is we first of all want to ferret out every single opinion that they have in the case first. Many times when you're taking these expert depots, you'll ask them what opinions they formed, and they'll start by kind of telling you one of the opinions, and then they'll start throwing a bunch of data at you, and you got to stop them from doing that. You got to say, look, I'm just looking for the universe of opinions that you have formed in this case. Now that you've been hired as an expert, you've reviewed this case, tell me what opinions you formed in this matter. And if they've formed 3 or 4 opinions, you make them exhaust every opinion they formed. Then you can go back to the first opinion and say, okay, now your first opinion was X. Tell me what data you used. Tell me what you used to formulate that opinion. What basis did you have for that opinion? And so the court, I think, is right here. And there's no change by this finding. The evidence code has always said you can't use speculative information as an expert witness for to base your opinion on, and you certainly can't have a speculative opinion that has no basis in medicine. And so this is a good. I'm glad this case came out again. I'm glad that the Supreme Court of California looked at this and said, hey, we're just going to make sure we tell the courts one more time and the lawyers that appear in those courts, you got to have good experts testifying on these important issues.
Well, it's kind of interesting because when you said, like just now, when you said that there's a certain type of medicine that would reverse the effects of dementia. Well, if a doctor said that, somebody who I thought knew what they were doing in this area, how would I know any different? I mean, I'm not a doctor. I certainly don't read medical reports or journals or whatever doctors read to get up to speed on this stuff. And so you're saying, well, there's a chance that the disease could be reversed if you take a certain kind of medicine. Okay, I guess I'll believe you then, because what am I to do? As a layperson, what am I to do? Even as an attorney that litigates in this area, you and I aren't experts on dementia by any stretch of the imagination. We work with a lot of experts on dementia, and we expect them to give us their honest opinions, but we don't have a way to fight, I guess, bad information. And so if somebody's taking a nugget of truth and they're trying to expand it beyond what is reasonable, how do you even know that they're doing that? I guess, would you get another expert to come in and say that's not the standard, the industry standard, or how do you fight that?
That's right. So you get your expert to come in and educate you on the case, because again, you're saying, look, I'm a smart trust litigator. I deal with this stuff. I'm confused by it. So you get your own expert, and then what you do is you bring a motion, generally by way of what we call a motion in limine, before the trial starts, and you essentially have already taken that opposing expert's testimony or his deposition, and you've got in that deposition, you've got all the opinions and all the bases for those opinions. Mm-hmm. And if those are not grounded in science, then you would bring a motion in limine and ask the judge, based upon this line of cases that the California Supreme Court just recently looked at and said, look, this is speculation. The underlying data is speculative. The testimony is speculative. Don't confuse a jury, or don't let the judge in a bench trial be confused by this, because judges, while they're smart people too, they can't combat an expert that's been a psychiatrist for 30 years and studying in the field. So if you think about what this really is the evidence code is the court's ability to be the gatekeeper of information that comes in to a trial. And many people, they'll call us up on the phone and say, oh, I've got the best evidence you've ever seen in this case. Okay, well, my response is, do you have any admissible evidence? Because courts aren't going to allow every fact, every document, every witness into a case. There's rules you have to follow, and in this case, the expert has to use proper data that's accepted by the scientific community, and then they have to make opinions that are not speculative. They're based in some scholarly underlying articles, some type of research that people can look at and say, yes, that's bona fide science, that's good data, we can rely on that.
Yeah, it just seems so nefarious. I mean, it seems like it'd be so easy for an expert to come in, pull the wool over everybody's eyes, because who's there to say otherwise?
Right.
I mean, I can't say otherwise. I guess my expert would have to say otherwise. And not only that, but what about, I mean, you get these medical records, you'll go back and you'll get medical records from whatever time period you need them, and you'll look through them, and usually we'll look through them before we hand it over to the experts just to see what we can find. And
just one second. Go ahead and take a look at that and see what's going on.
Yeah.
See the yellow up there? I think it needs to be green, where it says live.
Oh, yeah. I bet you it's our... it might be our Wi-Fi back here.
I don't know, but it just shows a black screen on YouTube.
Oh, does it?
Yeah, and I tried it on Cindy's computer too. Do I stop them or let them just keep talking?
Stewart's thinking maybe our stream health isn't so good up top there.
We need it green.
Yeah, I think it might be delayed. I wonder if maybe you could get somebody's laptop and have them take a look at it. Well, this is what happens when you do the first live broadcast, is you have to work out the bugs. But anyway, I think we're recording, so let's finish the thought, and we'll kind of see where we end up.
Okay.
So you get all these medical records from way back when, and whatever the time period is, and you look at them. We tend to look at them before everybody else looks at them, right? And then you see that there are mentions of things like dementia in there, but they're just barely mentioned. It's kind of like, prior diagnosis of dementia or prior signs of dementia or whatever. And there's nothing real meaty in some of these medical records. Sometimes there is, but a lot of times there isn't. So there hasn't been a full neurological workup on the patient, or there hasn't been even a mini mental exam done on the patient. Yet there's notations of dementia in the record.
Right.
I mean, what does an expert do with that? How do you deal with that? I mean, it doesn't seem like it's very strong evidence for an expert to go on.
I think that you have to look at the diagnoses, when it occurred, and how long this person underwent this condition. I think one of the problems we see with dementia is it's mentioned in the medical records once by the treating doctor, and then the treating doctor continues to see that patient after that, but doesn't update that diagnosis because they figure, well, I've already made that diagnosis. And so we don't see a lot more in the medical records. So in that case, we'd want to take that treating physician's deposition and talk to them about the care that they gave their client, and ask them, when you first diagnosed this back in 2015, did it get any better after 2015? And of course, they'll testify, no, it didn't. Again, if they're family physicians, they may not be neurologists, but they're certainly entitled to give their opinion on their client and what their patient and what their patient was going through. The other thing we can do is we can then turn these medical records with that deposition testimony from the treating doctor over to our forensic psychiatrist or forensic neurologist, and they will then go through that and recreate with their expertise kind of what this person was doing, what they were feeling, what the progression of the disease is in most people. And that's what we're looking for. Is the opinion really is, does this person have a weakness of mind? And dementia is not a light diagnosis. I mean,
Oops, and that's what I get for not silencing my phone.
there's moderate cognitive deficits when you're talking about dementia. So dementia, it's a bad diagnosis. And the question is that person now susceptible to the exercise of undue influence? And I would say, if somebody's susceptible just by age alone, if they're in their 80s,
Right.
and they don't have dementia, they're susceptible. They certainly are if they're in their 80s and they have dementia.
Yeah, I mean, there's other indicators besides dementia. We always focus on dementia, yet for undue influence, age, illness, circumstances, major life events, there's a lot of different ways that people can be susceptible to undue influence besides just one way. But then the other issue that you come across from time to time is you get the medical records back, everybody is sure that this person had some sort of dementia or something's wrong, and there's not a word of dementia in the medical records. You can't find it anywhere because it was never documented, or they didn't go to the doctors that often or something. So what do you do in that instance?
So again, that's where you're going to have to spend the time going through the totality of the circumstances. You're going to have to get as many witnesses as possible that were around this person towards the end of their life, their family members, their caregivers, anyone you can find that can give an opinion as to what was their mental functioning, their mental capacity, what was it like. And, most people can make a determination when an older person's short-term memory goes, because the older person, or not always older, but the person suffering from dementia, they'll tell the same story over and over again, or they won't remember something that somebody just told them a few minutes ago. Or they'll try to take their medication 3 or 4 times the same day when they're only supposed to take it once a day. So those things do happen, and people can testify to those events, and family members and friends that are closest to the decedent before they die, those are very good people for that testimony.
Yeah. Yeah, I mean, that's where I guess you just have to build the case from what you have. It's unfortunate, though, because that happens more often than it should. And when somebody is suffering from dementia, it'd be nice to be able to have that documented, but there's times when it's not. And I guess that's when you really run into these problems of people coming in and saying, well, I've got a great case. You'll never see a case like this. And then you get the medical records, and it's just so deflating to see nothing in the medical records,
Right.
when it's supposed to be a great case. And it doesn't mean it's not a great case still, or it's not at least a good case still, but it's not as good as if you had some good stuff in the medical records that you could really tie into.
That's right. And keep in mind, too, just because the word dementia is not in the medical records, which, again, it's rare when that happens, when somebody truly is suffering from it, but you can then go through the medical records and you'll find other things that say things like the person forgets one moment to the next. Some of these doctors are saying they're not oriented to time and place. So they don't exactly say dementia, but they do show that there's some confusion. The patient couldn't find their way to the office today, and it's an office they've been to on multiple occasions. The patient doesn't know who the President of the United States is. Sometimes these doctors will just give a mini mental state exam, and that can be good too, although those are bad. I've seen in the medical records where you have somebody that clearly is demented, somebody that clearly is suffering from long-term exposure to dementia, and they do quite well on a mini mental state exam because they're
Right.
well educated. And you do see this, and the good doctors, and you'll see this in the medical records, the good doctors note that and say, please, caution, do not put too much weight into the mini mental state exam and how well they did, because I'm with this patient and they have significant short-term memory impairment. They forget one moment to the next. I think they did very well on the mini mental state exam because they're highly educated, or they were, somebody that did some high functioning in life, a pilot, somebody an engineer, somebody that did something somebody that did a lot of test taking. Maybe lawyers would be a good example of this, or a physician, somebody that had to pass a lot of exams in their lifetime might do very well on a mini mental state exam, even though they're suffering from dementia and Alzheimer's.
Yeah, and that's the tricky thing about this whole area of law, if you think about it, is just how hard it is to get your hands around whether or not somebody had capacity or was susceptible to undue influence. And ultimately, it's the judge that's going to make the decision anyway, or the jury. It's not a medical expert that's going to make this decision. It's going to be the judge or jury. And normally it's the judge. And that person is going to have to decide capacity, yes or no. And most of the time, I remember I wrote that chapter in this psychiatry textbook, and it was two doctors and a lawyer, and we were writing the lawyer part. And I remember the language, it was being updated, it was a major update, and the language that was in there from a prior lawyer, said that it was easier to prove capacity than undue influence. And I remember that shocked me, because I'm like, no, it's not. I consider it the reverse.
Right.
It seems like it's easier to prove undue influence than capacity, because with capacity, you're relying almost solely on the medical evidence plus some of the surrounding circumstances and the expert. And you know what you're going to get on any case where you have an expert, you're going to get a competing expert. And it's going to be expert versus expert. And ultimately, the judge has to decide, and in something like 70% of the cases, they have statistics on this, but something like 70% of the cases, the court's going to validate the will or trust. They're not going to overturn it based on capacity,
Right.
unless they really feel compelled to do so. So that means that even a good case has maybe a 30% chance of success, and then it could go up from there depending on the facts and circumstances. Whereas with undue influence, there's so much focus on the wrongdoer because you're focusing on what they did and the actions they took, and the capacity part of it is really kind of minimal, which is just, is this person susceptible? And once you check off, yes, they're susceptible, then you really don't look at the person who did the trust or will anymore. You go almost exclusively to the bad actor. And the reason why that's an advantage is now you're putting the bad acts essentially on trial,
Right.
right? The bad acts that this bad person did, that's what the trial is about.
Right.
And you really can't have a competing expert on that. The facts are what the facts are. I mean, you can have competing fact witnesses, but the facts ultimately are going to speak for themselves one way or another, and it's not going to be a battle of the experts.
Right.
What do you think about that?
Yeah, I think so. And probably we've talked to some jurors after a jury trial, and we've talked to judges as we do mediations, and they generally say that if there's two experts, and as long as they're both reasonable experts, they're just going to offset each other, and then it's going to come down to the lay witnesses and what people testify to. And keep in mind that just like jurors make decisions from their gut of fairness, from their life experience as they look at a case and they determine how something probably went, I think judges are the very same.
Right.
They may be a little bit more jaded than your average juror just because they've
Right.
done so many trials,
Right.
but I guess they would say experienced. But they make a decision from their gut. And if you can show them that they've done bad information, if you can show them that the document is likely the product of undue influence, you're going to probably win that case because the judge is then going to back themselves into what the law of undue influence is, whether it's by direct evidence of undue influence, or if it's done by the burden shift, where we're able to shift the burden of proof to the bad actor, and they have to prove that they didn't unduly influence anybody.
So this brings up a really interesting point, which is the story matters, right? So in order to get a judge or jury to rule in your favor on these cases, and probably just about any legal case, but certainly on these cases, you have to build the story as to a compelling reason why the trust or will should be overturned. And so some stories play out better than others. And so, for example, if you have a neighbor who came in a week before the person died, and all of a sudden there's a new will, neighbor gets everything, and the kids get nothing, and in all prior estate plans, the kids were taking everything equally, I don't really have to tell you much more about that case for that to sound unfair, right?
That's right.
Whereas if you have a case that's a little bit harder to decide, you have two kids and one of them's had financial problems and has been always mean to mom and dad, and 2 years before somebody died, the estate plans changed, disinheriting that child, leaving it all to the other child. Well, that doesn't sound quite as unfair.
Right.
So fairness is not the legal standard. I mean, in undue influence, it's one of the four elements is equity, which is fairness. But it's not the legal standard, but it's interesting how it ends up being, from a practical perspective, what the whole case is about.
Right.
I mean, that's just, it's amazing, I think, how that ends up coming about.
Right.
But, how do you reconcile that with, okay, now we need an expert opinion? So you're kind of switching back and forth between, well, we need an expert who can make an opinion based on good, solid information that's not speculative. But on the other hand, we're going to weave this story together in a way that's most favorable to our client.
Right.
Which one's going to win the day?
I think the narrative, the story, I think the testimony of the people that don't have a dog in the hunt, I think their testimony is going to be taken very well by the court. So make sure you take good depositions in your case, and that way you know what people are going to testify to at the time of trial, and it makes your examination of them at trial even better because now you can tell the story through their deposition. And if they stray from that, you can bring them back. Sometimes they stray innocently from their story because it's okay that your memory changes a little bit over time. But if they stray fundamentally and maybe they switch sides or pick sides against you, you've got their deposition transcript there to hold them in line to what actually happened in the case.
Right. And here's another thing that we hear a lot. My mom never would have done this. My dad would have never done this. My grandfather never would have done this. My grandmother never would have done this. Is that evidence?
No.
Why not?
Because
everybody knows. Everybody knows that my mom or dad wouldn't have done this.
Well, and that goes back to where we get the phone call saying, we get people that call us. I'm not sure why they do this because I've never done this to like my knee surgeon. I've never gone into my knee surgeon and said, "Oh, I know exactly what you need to do on this knee surgery here, doc. You're going to first go into my ACL and you're going to," I don't even know where to begin, right?
Right.
But we do get people from time to time that come see us, not all of our clients, but potential clients come in and say, here's how you're going to handle this case. And boy, do I have some evidence for you. You've never seen evidence like this before. And whenever the consult starts out that way, I'm always a little bit nervous because we've been doing this together collectively, 30, 35 years, something like that. I'm talking about both of our years together. Yeah. And we've seen just about everything under the sun on multiple occasions. Yeah. So no, you can't just say mom would have never done this. That's not evidence. You're going to have to bring in some evidence to show that the trust or amendment or whatever it is that's been created by mom prior to her death is not valid. And you can't just say, she wouldn't have done this. I know my mom.
Well, and the funny thing is it's on that rare occasion, it doesn't happen that often, but rarely when people do call us and say, you've never seen a case like this before, you won't believe how good this evidence is, they proceed to explain something that we've seen 1,000 times, and it's on the lower end of the good scale.
Yes.
And then separately, you'll have somebody call in and they're more tentative and they'll say, I'm not sure if I have a case or not. And then they'll proceed to describe the world's best case you've ever heard.
Yes.
It's like, oh my gosh, yeah, you've got a case. Yes.
Yes.
Well, we'll consider taking it.
Yes.
And then you quickly write up the engagement agreement. But it's an odd thing. But I think part of it too is there's just so much confusion out there about what does it take. Like, for example, I'm a child, okay, my dad dies, and he's married to another woman, my stepmother, let's say, and she gets my dad's house. That can't be right. It's my dad's house. It should come to me.
Right.
I'm a child.
Right.
Now, you and I can agree on that from a logical perspective that, that sounds right, okay. But legally, how do you accomplish that? That's not so easy, right?
That's correct.
So you have to find out, well, how did your dad own the asset? And did he leave it to your stepmom like outright? Were they joint tenants on it? Did they have a trust where it goes to her? Did you have some retained rights in the trust? And here in California, at least, children do not have the right to inherit. They can be completely disinherited by parents, and too bad. I guess, where was it? There's some other country we were working with where there's actually a right to inherit.
I don't recall.
I think it was France.
Is that right?
I think France.
Oh, it was France. That's right. There was a certain amount. It was almost like the minor children here have a right to inherit something.
Yeah, and I think in France it was like you could not disinherit your children, which, you wonder about that. Is that a better system or a worse system? I don't know. You would think that it'd be worse just because, well, then the kids won't be nice to you. But in our experience, a lot of times the kids aren't that nice anyway. So I'm not sure you're getting anything by dangling an inheritance in front of them. But maybe it depends. It depends on the case.
So I have a thought and a question. It boggles my mind that we have these really complex trusts in California. Some of these trusts are 50, 60, 70 pages long. They've got all kinds of legalese in them, very complex provisions. Many times, even an associate attorney that's got a little bit of understanding of trust and estate law has a hard time wading through these trusts. But yet we have this fiction that the settlor intended and knew every part of that trust.
Right.
I mean, what are your thoughts on that?
Right. I know. And I don't know. I guess some things we do in the law just because there's no practical way to do it otherwise. But you do have, a short trust, a small trust is about 25 pages. An average trust is 40 to 50 pages. A long trust is 100 pages or more. We've seen them all. I've seen trusts that are 120. So have you. Trusts that are probably as short as 10. I don't care how long the trust is. You could tell me it's a 10-page trust. I guarantee you the person who signed it and created it didn't read the full document, most likely. There might be 1% of the population that does that, but 99.9% of the time, the person who signs it is not sitting there reading through all of it. And, I have a trust. You have a trust for your own family. I don't think I read through all of my trust. It's like, a big chunk of it is the trustee powers. That's boilerplate. You don't have to worry about that. But then there's other things in there that are near the bottom that are considered boilerplate that are hugely damaging to beneficiaries. So, for example, exculpation clauses where you say that, the trustee can't be held liable unless they acted, willfully or in bad faith. And then you have accounting waiver clauses where the trustee doesn't have to account. You can still force them to account if you go to court, but they don't have to account. Now that we've been doing this for a while, that seems insane to me, that you would allow a trustee to not have to account. Doesn't that seem crazy to you?
Yeah, and I not only not account, but these exculpation clauses you just talked about, I seriously doubt this is something that people ever think about. And the way it's probably presented to them in a meeting, if at all, is, you pick your trustee, you trust them, you don't want them to have to be held liable for just negligence, right? And so then people are like, oh no, I want them to, only if they do things in bad faith or they're actually intending to cause harm to the trust. And that's not how it works out in practicality. If you look at these exculpation clauses, they're real bears to deal with if you're trying to hold the trustee liable for breaches of trust.
It's really hard. And the problem with that is proving bad faith is not that easy because a lot of times judges aren't quite sure what bad faith is. It's kind of like saying, what is reasonableness? There's a lot of reasonableness in trust law. So the trustee has to act reasonable, and they have to invest in a reasonable, prudent manner, and they have to distribute the trust assets within a reasonable amount of time. What is that? What is reasonable? And so it becomes a real problem. But yeah, I think the problem with the trust provisions is, number one, nobody discusses these things. So I bet you anything that more often than not, people who have an exculpation clause in their trust are not talking about them. They have an accounting waiver in the trust, they're not talking about it. And we see a lot of problems where a married couple will create a trust. After the first spouse dies, you're required to create these sub-trusts like the bypass trust, survivor's trust. That doesn't happen.
How many times have you spoken to a surviving spouse that knew that they gave up 50% of their property on their deceased spouse's death? It's
shocking.
Yes.
Think about that. You're living, in a long-term marriage. Let's say you were married 30 years, and your husband dies, and now you only own half your house, and you have to do new deeds, putting half of the property into a bypass trust, half into a survivor's trust. And yeah, you still control both halves, but you don't have unfettered control of the half that's in the bypass trust. That's locked away in an irrevocable trust. And now you're telling this widow, well, that's just the way it is.
Right.
You signed it.
Right.
You read it, didn't you?
Yep. That's right. Yeah. Explain that.
Yeah.
My guess is that client's not going to be very happy with you.
And that's why these things aren't created.
Right.
And so they're not created either because somebody doesn't go see a lawyer, or if they do, the advice they get from the lawyer is not favorable. And so they just don't. And then the next thing you get into is people wanting to change the trust terms. You can't change the bypass trust terms. They're locked in, but they still want to.
Right.
And so now they're either moving assets out of the trust to try and escape it. They're doing amendments that they shouldn't do. It gets very, very messy.
Right.
Very quick.
Yes.
So, I mean, I guess that's why you have trust and will litigators, is because it gets messy very quick. But it's unfortunate that people don't understand what they're getting into when they sign a trust in the first place, and really from a practical perspective, what the terms mean. I mean, how would you know? How would you know what an exculpation clause even means? And when you're doing it, your estate planning lawyer is going to tell you, well, it just helps protect the trustees so they can do their job without being harassed, or they're going to say something like that. And, oh, okay, well, that sounds good.
Right.
Yeah, I want the trustee to be able to do their job.
Right.
What if the trustee's a bad trustee that is getting away with things? Or worse yet, the trustee is a sibling and the siblings have never gotten along. That's another thing that we get into all the time, is sibling rivalry, right?
Right. Well, Keith, this is our first show that we've kicked off. We've been going for about 30 minutes here, and it looks like we have 4 people joining us. Obviously, we'd like to hear if anybody has any questions. In the meantime, I'll ask you a question. If my brother and sister have recently been taking my mom to go see an attorney, and it's my understanding that they're trying to keep my mom from seeing me, and I'm a little bit upset about that. How can I mean, should I go to my mom and tell her, don't let them trick you, and should I try to take mom to my own attorney? I mean, what should I be doing so that I'm putting myself in good light going forward when, after my mom passes, I won't look like the greedy heir. I won't look like I'm the one that's really causing all the problems.
And I really wish I had a magic wand for those situations, because they might be the toughest situations we encounter. I mean, so you're saying, how do you protect a parent during life while the parent's still alive, and you really don't have any control over them? You don't have control over where they live.
Right.
You don't have control over their finances for whatever reason. Other people are coming in, probably siblings, and like the example you just gave. So they're coming in and attempting to control things that you're not going to be able to compete with them on that.
Right.
It's a race to the bottom, I guess. So what do you do? Well, number one, from a legal perspective, what you would have to do is you have to go and file for conservatorship over mom. That's really your first recourse, and the reason why that's really your first recourse is because when it comes to the trust, if it's a revocable trust, you don't have a right to take any action on that trust, even though you might be a remainder beneficiary after mom dies. If it's revocable, only the person holding the power to revoke can do anything with the trust, can sue the trustee, can ask for an accounting, whatever. So if mom's the person who can revoke the trust, only she can do that. Well, she's being manipulated. She's not going to do that. So how do you force the issue? Now, you could do it as a remainder beneficiary if mom no longer has capacity. But that begs the question of, well, does she or does she not have capacity? And who's going to make that decision? Ultimately, the court has to make that decision. And so the only real way to make that decision or go to the court to make that decision is with a conservatorship. So you file a conservatorship action, and you try to have yourself or somebody else appointed as conservator of the estate or the person so they can control mom. And then the conservator can take action against the trust because they literally step into mom's shoes. The problem is, though, on a conservatorship, in order for me to get conservatorship, I have to go to court and say to the whole world, either mom has lost her mind, she's incapacitated, number one, or number two, she's being unduly influenced. And that all those papers are going to go to mom. Mom's going to get her own lawyer appointed by the court, and she's going to see everything that you just said about her. And how's mom going to like that?
Generally, mom's not happy.
She's not happy.
She doesn't like being told that she can't do with her estate and with her person as she wants to.
Yeah. Yeah, we all like our autonomy, our freedom, right? And now you're trying to say, well, not only can she not have her freedom, but it's because she simply doesn't have the capacity to do it.
Right.
I mean, you're literally suing your parent.
Right.
Now, you're doing it for a good reason. You're suing your parent to save your parent, but your parent's not going to see it that way, probably.
Yeah, I have a saying. I don't know if I got it from somebody. I'm sure I did, but it's if you're gonna shoot for the king, you better hit. And here, if it's a mom, if you're gonna shoot for the queen, you better hit, because if you don't, the bad acting siblings, or if there's one bad acting sibling, is gonna take that conservatorship pleading to your mom or dad, and you can guarantee they're gonna say, I can't believe that your son has done this to you.
Right.
He doesn't love you. He doesn't care about you. And then you start acting out in a way to protect your mother by attacking your sibling, who does a very good job of acting very pious. And it looks like you're the greedy heir. And what you've done is you've sown seeds so that after your mom passes away, when you do in fact file a trust contest to invalidate any amendments the bad sibling got her to sign, you look like the crazy one.
Right.
And mom has said horrible things about you because she believes that you're trying to take her rights away.
Right.
So my advice to somebody in that position has been, it takes real discipline, and it's very difficult to do, is don't do anything other than give mom the best sunset years that you can. Sunset months, sunset days, however long mom has left. Just be a good son or daughter. Show up. I mean, rare do you find where a sibling keeps you from seeing your parent at all. Go see your mom. Hold her hand. Don't talk to her about a trust. Don't talk to her about the will. Don't talk to her about conservatorship. Just love her, care for her, and when she passes, if that were to happen, then you're in a position where you don't look so bad. And there's probably some remedies out there by way of a trust contest, a will contest, or a financial elder abuse lawsuit to remedy the wrongs of the bad acting sibling that you've had to deal with.
Yeah, it's really tough because you want to help your parent, but there's times when you have to make really hard choices. And of course, unfortunately, after a parent passes away, then you have rights to go after the trust on your own. But a lot of good that does you when you're trying to help a parent. I mean, it doesn't really help, while the parent's alive. It's a really, really tough area of the law. We used to do conservatorship actions, and they are hard. And the reason they're hard is because there's just no good resolution. I mean, somebody always is going to lose on a conservatorship action, and usually it's the elder because they're kind of drugged through the mud, sometimes for their own good, but it's still being drugged through the mud for their own, in any event. So, so that's probably one of the hardest things that we'll ever come across.
It is, and I feel like if you can wait, if you can have the discipline to get through that, I think that's better for your parent in the long run. And then once they're gone, if you feel that you need to remedy any of the wrongs that have been done against your parent or against you from your bad acting sibling, then you can do that.
Right. So in terms of, let's go back for a minute to the expert issue that we were talking about at the start of the show. So let's say you have an expert, and let's say that there's somebody there who is, somebody's trying to opine on something like there is this drug that the decedent was taking, and it was reversing the effects of dementia. You know that to be probably bad science. What are you going to do in the deposition of that expert to try and tee them up, to set them up, to attack them later on with your own expert?
Well, again, I think taking, and we could do a whole program on the strategy for taking on a defense expert through deposition and at trial. But ultimately, you're going to have certain things that you need to find out from the expert. And it's really two primary things that you want to find out. Number one, what are the opinions that expert has formed in this case? Are there any more opinions they anticipate forming? lock them into the opinions and get each one in detail. So I generally will ask the expert, how many opinions did you form in this case? And if I find out they formed 3 opinions, I'm going to exhaust every different way of looking at those opinions to make sure I understand expressly, implicitly, any other way, exactly what their opinions are. And then once I understand those opinions, then I'm going to ask them for the basis. And so for the example you gave, I'd be asking, what scientific journals did they look at? What research did they look at? What other physicians did they contact? Who have they talked to that says that they can reverse dementia? Because if that's true, you're going to be a multi-billionaire, because it's just something that
Right.
isn't available through science today.
Right.
And so I think that's basically what you want to do, is you want to lock them into their story. I almost always will ask the expert at the end of the case if they anticipate doing any more work. Do they anticipate doing any more research of the materials? That's the other thing that's fun to do with most experts. Attorneys that hire experts are very cost conscious, generally speaking, defense attorneys and plaintiff's attorneys. And so many times the attorneys will decide what materials to send over to the expert to review. Mm-hmm. And so I always ask for, what materials did you receive to review? So I've got their opinions. I've got the bases for their opinions. Now I want to know, what materials did you review in this case to form these opinions? And in many cases, it'll be a handful of medical records that are cut across a period of 5 or 6 periods of time, but not all the other medical records in between. Mm-hmm. And I'll say, who provided these to you? Well, invariably, it's the attorney that hired them for their opinion. And I'll say, did that attorney consult with you on what to get you? No. Did they ask you, did you want any other documents? No. Did you ask for any other documents? No. So let me get this straight, doctor. You reviewed this case based upon only these carved up pieces of medical records that have been presented to you by the attorney that hired you. Yes. So that's a good way to be able to lock them in and show that they didn't do a thorough analysis in forming their opinions. And of course, with your expert, if you've done it right, you've given them everything. And of course, you've said at the end of each email or letter you send them, you let me know if you need anything else from me. And that way, and a good expert, the good experts that we hire, they do follow up with us and say, is there any other medical records from this doctor? Because I read through the medical records, and there's this one neurologist that did something 4 years ago, and I don't see it in the medical records. Can you get it for me? I'm like, yes, sir or ma'am, we'll go get it for you, because we want you to review it.
And that's when things get expensive. I mean, it's clearly more expensive to work with an expert in the right way. You're talking about tripling the cost versus trying to just give them a limited amount of information. But like you said, then they're subject to being undercut, and you're going to undercut them all day long if you know what you're doing on an expert depot. And it's not worth the money, right? It's penny wise, pound foolish, I think, at the end of the day.
Yeah, something else about taking defense experts. Google is so powerful, and many of these experts, they have a website, they have publications, they have books, they have periodicals, there's some research out there, and of course they want to be known, right? And so they have to put their opinions out there. And I remember I was taking an expert out of UCLA, and he was one of the top experts in the country in this particular field of medicine. And this was one of the cases where the attorney that had hired this expert had given them very few scant medical records to review. But I also found an article that they had published about 5 years earlier, and it really supported our position in the case from a dementia standpoint. And there was a whole series of paragraphs in this article that this expert had published that supported our side and would not support the other side's case. And so once I had established all of his opinions, all the bases, what he had reviewed, what he had not reviewed, what he didn't know was out there, I then asked him if he would agree or disagree with the following statements. And I read each one of those sentences that I had pulled from his scholarly publication from 5 years earlier, and he disagreed with every single one of the sentences. So then I handed him the research paper afterward, and I'm videotaping this deposition.
Yeah.
And he looks at it, and he looks at the video, and he goes, oops. So,
that's a rare deposition, but it sure is fun when it happens.
Yes.
It's like gotcha.
Yes.
It's not that often that you get gotcha moments in depositions, but that's a nice one.
Right.
It's so interesting, too, just because experts, I don't think that you can deal with experts necessarily head on. I mean, that's a rare example that you just gave where you pretty much could hit him head on because you knew that he had contrary information. But you have to figure out a strategy and a way to undercut that expert. And it's not typically hitting them head on. It seems like it's typically you're going to, what did you review? What was your method? How are you doing these things? There's an angle that you can find if you think about it long enough that is going to give you the edge that you need.
Yeah, I think you're right, Keith. And I think that I think what you're getting at is you don't take an expert on in their expertise.
Yeah, right.
It'd be like somebody that didn't do trust and estate litigation come in and cross-examining us on trust and estate litigation.
Right.
What you do much better is saying, well, Stewart, what did you review for this trust litigation? And do you think you could have reviewed these other things? And if there are things that you should have reviewed, it puts you in a really difficult position because you sound foolish if you say, no, I shouldn't have reviewed those.
Right.
Or if you say, yes, I should have reviewed them, well, that's damaging because that could have impacted your opinion in the case. And that's the follow-up question you ask the expert is, did you review the medical records from this 2-year window? And if they say no, you say, do you believe that those could have impacted your opinion? There's only one way they can answer that, and that is either I don't know because I need to review them,
right?
But then you can reinforce that they didn't review them,
right?
Or they're going to say, yeah, I think that if I read 2 years of medical records, that could impact my opinion.
Right. Yeah. Yeah. I mean, I think it's just a matter of finding the right angle and then going for it. But it's an art. Definitely more art than science. It's something that you've perfected really well over the years, but it's because of trial and error, I think.
Well, and I think the one area, and I think I see a lot of plaintiff lawyers that make a big deal out about how much money these experts are being paid. Mm-hmm. I don't think that has the strength that it used to. I think that how much an expert is paid, everybody understands in today's environment, people are paid for what they do. I mean, the lawyers are paid in the case for what they do, right? And so unless the expert's receiving 3 or 4 times the amount that all other experts in that particular field are getting paid, I personally think you stay away from that. But I certainly think you can ask, do you normally represent trustees or do you represent beneficiaries? And if all you've done is represent trustees or trust or lawyers that have drafted documents, if that's primarily the opinions you've given, I think that's fair game. We need to look at that and show that you're not balanced in the way that you represent people with your expertise.
Right. It's interesting, too, the other aspect of expert witnesses that a lot of people don't realize is how they present in court. I mean, that's really where it counts, right? Because you know that you're going to get battle of the experts in the depositions prior to court. They're both going to say the opposite of the other. And yet, we had a case many years ago where we had an outstanding expert, but he didn't necessarily present so well in court. And then once we were in trial, he kind of, fell apart a little bit. I mean, he just became he wasn't able to relate to the judge or the questions very well. And then the other side's expert was just like Mr. Suave, and, he had the judge eating out of his hand. I mean, and I don't think that one expert was more qualified from an educational standpoint or experience standpoint. That was purely a personal skill. And we learned a lot. I mean, this was, 8 years ago. We learned a lot from that just because personality and being able to connect with the people in the courtroom matters.
I thought we might have a problem with our expert when he showed up at the courthouse and got outside of the car, right out in the front of the courthouse, and took his shirt off.
Right.
And
to change his clothes. In the street.
And then when we put him up on the stand, he brought this canister with tea, and he opened it up and poured some, and he would drink from it every few minutes while we were. So that's again, that was a bad on us for not meeting with him ahead of time, maybe seeing that he was a little bit different and odd. And of course, we did have the unpleasant experience of going against that particular expert, the opposing side's expert in that case. But then we've used that expert, the opposing side's expert, several times going forward, and he's quite good. Yeah,
we've learned real quick that personality matters. And so we want to have somebody with the right personality up on the stand giving our side of the case to the judge, because you have to make that connection, that personal connection. I mean, at the end of the day, law is a people business, right? I mean, it just is. It's a group of people coming together to resolve a case. And you've got the judge, you got opposing counsel, you got experts, you got fact witnesses, you got treating physicians that come in. I mean, all these people have an impact on the process, and how well or poorly they present in a courtroom makes a huge impact on the result. And, you know, the people who you think are going to do great sometimes don't, and the people who you think are going to do terrible sometimes do outstanding.
Well, I'm glad that you raised that. You went through a whole series of people that bring the facts, witnesses, or the facts and the documents to life in a trial. I think if you get a really good treating physician, they're gold.
Yeah.
And the reason they are is because, again, they're not seen as being paid for this particular case.
They were actually the one there treating the decedent prior to the decedent's
That's
death.
right. That's right. So, but the problem with them is they're not professional experts that are used to being in court or even having their deposition taken, and so they can be abused by the other attorney. The method I have for them that I think works quite well, and maybe I'm giving too many secrets away, is I go through the medical records with them, all of the medical records, right with them at deposition, so that it refreshes them. So I'm not just asking them questions that they feel on the spot and they feel they have to make something up, because maybe they'll not make something up. That's too strong a way of putting that, but filling in the gaps. I'd rather have them take them back through all the medical records, make sure they see everything, and then I start asking them. And I'll even bring them back to the beginning, and we'll walk through it together again one more time, just to make sure that they have a full flavor of what they did during the treatment plan. Because, I mean, most physicians don't remember these patients that closely. They see so many patients.
Right.
And so and they have some recollection of the patient, but in many cases, they don't remember the actual diagnoses and the dates and so forth.
Right. Yeah, I mean, it's a lot to deal with. It's a lot to consider. Well, this is our experiment, our first live broadcast on YouTube, and we hope to bring you one of these each week. Feel free to email us any questions you have in advance. You can always email myself, which is keith@aldavlaw.com, or Stewart at stewart@aldavlaw.com, or you can just join us and ask questions as we go. Thank you so much, Stewart. This was fun to do as kind of a fun experiment, and hopefully it keeps growing.
All right, sounds good.
All right. Now let's just figure out how to stop the stream.